Mr. Stanzanelli, we try again. Please press the speak button at the bottom of your screen. Thank you. Good afternoon, Mr. Halicki. We can test your connection. Please press the speak button.
Good afternoon. Is it okay? I can hear you, I can see you, so I hope everything is
Yes, we
fine.
can hear you, but we cannot see you. Please.
Okay. Moment, please.
Okay, now I can see you as well. Okay, everything is fine. Thank you.
Much better.
Yeah, thank you.
Thank you very much. Thank you very much.
Good afternoon, Mr. Le Breton. We can test your connection. Please press the speak button. Thank you.
Bonjour, je vous entends très bien, donc pour moi tout va bien.
Bonjour, c'est bon. Ok, merci.
Good afternoon. We start today's Jury Committee meeting. We have interpreters for the following languages: English, French, German, Dutch, Spanish, Italian, Danish, Finnish, Czech, Estonian, Polish, Bulgarian, Romanian, and Croatian. Time slots, except for the opening and closure of the vote and the start of the in-camera session, are indicative and may change during the meeting. If there are no objections, I consider the draft agenda adopted. Item 2, Chair's announcement. On March 29th, the first opening trialogue on the country-by-country reporting file was held. We will invite the rapporteur, Mr. Iván García Blanco, to report on the progress of the trialogues at one of the forthcoming meetings. Now that we have the quorum, as I understand, the vote will be open from 13:55 to 15:15, and we will announce the results by email. I want to draw your attention to the fact that only members whose names have been communicated by their political groups as participating in the vote today will receive a link in order to cast their vote at the moment when the vote will be declared open, and only their votes will be counted. Also, only the votes received during the time the votes are open will be counted. All members taking part in the votes will vote by EP Vote email by entering the voting choices online in EP Vote using the generated PDF ballot paper, print, sign, scan, and send back from your official EP email to the functional mailbox. I will also draw your attention to the fact that for your vote to count as valid, you should be present at the committee meeting during the vote, either remotely or physically. We will vote today the amendments on item 4, challenge of sport events organizers in the digital environment. And, well, the vote will be open in 5 minutes from now. We move to item 5, exchange of views with European Patent Office. I would like to warmly welcome, I see that I have hand raised. Mr. Breyer, would you like to take the floor?
Thank you very much, Chair. I would like to say a few words on top 4, if I may.
Sorry, Patrick, we lost the connection, so we couldn't understand you. Could you repeat?
I would like to say a few words on top 4, on the sports events organizers, if I may.
But if it's a point of order, yes. If it's something on the content of the report, no, because we have already discussed this item. But if it's a point of order, yes, you can take the floor. But if it's on the content, I'm afraid that I cannot give you the floor, Patrick.
Okay, I see. No, it's on the content, so then I can't speak.
Sorry, yeah, because we already had this discussion in the committee. Thank you for your understanding. So we move on item 5. Exchange of views with European Patent Office. Now I would like to warmly welcome the President of the European Patent Office, Mr. Campinos, to our committee meeting today. We have invited you to discuss the latest state of play of the establishment of the Unitary Patent Court and the associated Unitary Patent System. The ratification has been delayed a number of times in recent years, most recently as a result of new legal complaints raised in Germany before the Federal Constitutional Court. We are glad to have this opportunity to hear from you what could be the way forward, and we also welcome this exchange of views as an opportunity to discuss other patent-related issues. As with the current pandemic and technological development, patent has become highly topical. I will give you 20 minutes maximum. I will let you know when you have just 1 minute left. The floor is yours.
Good morning, everyone. Dear Chair, members of the committee. Firstly, I want to thank you for inviting me to this meeting and for giving me this opportunity to say a few words. The last time I had the pleasure of addressing a committee here was back in 2018 as head of the EPO, the Trademark and Design Agency back in Alicante. Back then I was, as I said, representing EPO, but it was also something of a different world. One where I could have sat with you in the Joseph Antel building, innovation, thankfully, means we can still meet and discuss practical issues. Video conferencing is just a small example of how innovation has helped us address the challenges of the pandemic. But of course, innovation's contribution to dealing with this crisis has been far greater, in fact, central to our efforts to tackle the pandemic. It's given us new medical technologies to treat the sick, and, for example, software to track the development of COVID-19. Behind those innovations, behind the advances and the breakthrough, of course, is a solid intellectual property system. One that doesn't just support the commercialization of new technologies that save lives, but also generates the kind of economic impact that can help Europe get back on its feet. In our last study we carried out with the EPO, we found that IP-intensive industries generate 45% of our GDP. and account for close to 40% of our employment, directly and indirectly. And as we know from previous experiences, from the last financial crisis, it's also IP-intensive industries that prove more resilient in the face of economic shocks. But in recent times, there's no doubt that intellectual property and our whole IP system in Europe, and indeed across the world, has come under scrutiny, and rightly so. The patent system is only there to be an effective tool, among others, to encourage technological breakthroughs and advances for our society. Now, I know that access to medicines may come up in our discussion today. It's been the subject of much debate, given the pandemic. And we're following that very closely, of course, because access to medicines is an extremely complex topic. So we're ready to provide any information needed to the jury committee and your colleagues throughout Parliament and civil society on the patent system and any technical information that may help. As an internal governmental organization with 38 member states, many of whom are EU member states, we see this very much as a part of our commitment to work ever more closely with EU institutions. At the EPO, our focus is on making sure the patent system fulfills its fundamental aims and that it's truly capable of having a positive impact for the whole of society, starting with the fact that the patent system must always provide an incentive for innovation, especially in cases that typically require large and risky investments and where there are long cycles of development and regulatory approval. If we are to make sure that incentive is real and encourages new research, our role at EPO has to be granting the highest quality patents. And we are recognized as a world leader in this field, with 3 examiner divisions comprised of highly qualified scientists and engineers who examine applications collaboratively. And to help, they have access to the world's largest databases of patent and non-patent literature. Those measures, and many more, like tough internal compliance audits and ongoing feedback with our users, mean that the invention is ring-fenced to the right degree, that we can reduce legal uncertainty in the technological market, and in doing so, we incentivize high-risk investment. But we can also support the wider innovation community by offering patent information to all inventors who want to build on the advances being made by their peers. Because the patent system requires that the invention and patent are made public and are free for all to build on. That's the inherent contract. Patents are made public, so society can progressively advance the state of the art. They can be a source of inspiration for scientists and inventors everywhere. Very importantly, sharing this information also means that inventors do not waste time, do not waste resources, do not waste funds looking into technologies that have already been invented. So we offer a database that has 130 million patent documents, including patent and non-patent literature, available for anyone to access free of charge. And it attracts around 600,000 users per month. We also offer a free translation service called Patent Translate in 32 languages, helping our users understand patent documents from all over the world, and of course, increasingly, including Asia. Last year, we also used the ESPASnet database to help combat the pandemic by launching an online platform that provides patent information on technologies specifically related to coronavirus research. That information also reveals how different technologies rise and fall in relevance. And that's a challenge we have to answer. and make sure that patent offices and the IP system can respond and adapt to this ongoing force of creative destruction. When the arrival of new technologies such as 3D printing, robotics, drones, gene editing, and nanotechnology can mean the fall of others. This has ramifications for patent offices at the operation level, yes. In the patent grant process, yes. But these new technologies, these creative forces, can also have ramifications at the legal level and raise questions sometimes on the legal foundations of the IP system. Technologies such as blockchain and AI, which are at the center of the fourth industrial revolution. At EPO, we've been seeing huge growth in that area. Since 2010, the annual increase in international patent families for IR technologies has been nearly 5 times greater than the growth of all others. So we have to make sure that our office and the European patent system is legally capable of dealing with these developments. I do think we have a solid foundation here. As I said, the EPO's comprehensive examination guidelines on computer-implemented inventions are constantly assessed and updated. The European Patent Convention also offers the necessary clarity on issues like patentable inventions and inventorship. We had a ruling on that last year, as some of you might remember, the famous Dabus case, in which it was ruled that an inventor has to be a human. But of course, we know we have to work together with our international partners to make sure our society is answering with a coordinated approach. Right now, we are working with the IP5, which includes the world's largest intellectual property offices, US, China, Republic of South Korea, and Japan, to investigate how AI remains an opportunity to boost the efficiency of the patent system rather than a challenge. And of course, intensifying cooperation with EU institutions is a goal embedded in our strategic plan. And in that vein, I also want to thank the members of this committee and the Parliament for the attention you have given the issue, particularly for your October resolution, which urged the Commission to do more to assess the impact of AI on IP rights, and importantly, to do so for the sake of businesses and the European innovation sector. And that brings me to my next point. Whenever we think about IP, granting high-quality patents may be one side of the coin, but raising awareness about the huge potential of those patents has to remain a fundamental part of our mission, especially for universities and research institutions, and of course, SMEs. The link between patents and the growth of innovative SMEs is pretty much documented. A survey of European SMEs showed that 2/3 of those that have filed a patent with the EPO succeed in commercializing their technology. They help to attract investors, enhance a company's reputation, gain a share of the developing market, organize efficient commercialization through licensing agreements, and build collaboration that help SMEs, given their more limited pool of internal assets. But the real question is how we can turn patent information into patent knowledge. Part of the solution is a network of patlibs, or patent information centers, which are run through universities, innovation centers, and other places all around our 38 member states. They give anyone who asks the information they need on patents. Right now, we are revamping this network, a Patlib 2.0, or maybe 3.0. So it's more focused on helping inventors commercialize inventions and make sure we move from fundamental research to applied research and to innovation. And we also have to make sure that everyone has the information available they need to make sound policy or business decisions. One of the ways we think we can contribute to this is by establishing a patent observatory to produce class-leading analyses that will help spot emerging trends and produce the information needed for taking effective policy or business decisions. To support that process, we also want the observatory to be a forum for rich dialogue and transparent debate, with a seat at the table from the private sector, NGOs, but also the public sector and its policymakers, including institutions, of course, like the European Parliament. But no matter how much information we provide, there is one issue that patent knowledge cannot address alone, and that is the current fragmentation and high costs of validating, maintaining, and enforcing patent protection in several states, which can still be very much prohibitive for many SMEs. Moreover, the fragmented litigation system makes it practically impossible for an SME to cope with parallel litigation in multiple jurisdictions, be it as a plaintiff or a defendant. In other words, the potential of the single market is not yet fully exploited when it comes to innovation and its legal protection. We are still missing one vital aspect which will support innovation and complete the internal market: the unitary patent. At its very heart, it will offer greater legal certainty, simpler administration, and reduce costs. In sum, it has the potential to create a more business-friendly environment. It will create a single European market for technology and will make Europe more attractive for innovation and investment, which is clearly important for Europe's strategic autonomy. In terms of numbers, we know from a recent report that further harmonization and a full alignment of patent protection would mean increases in high-tech trade and flows of foreign direct innovation by 2% and 50% respectively. That will result in annual gains of 14.6 billion euro in trade and 1.8 billion in FDI, to say the least. From our side, we're ready to start administering the unitary patent, having completed the legal and technical implementation of the unitary patent some years ago. It's now for the participating member states to take the next steps. But if I may, I'd like to close with a more personal thought on this issue, and that's that Europe needs the unitary patent to become a reality, primarily, of course, because it can help fuel an economic recovery by supporting innovation. But there is another important point. We also need the unitary patent for the next generation to come. In the last year, we've seen an incredible capacity to innovate and to overcome challenges. But that capacity to innovate is the result of previous decisions made over the years, decisions that have given us a strong IP system. So whatever the next great challenge is, and whenever it arrives, it is the decisions we take now that will affect how we are able to meet those challenges in the future. It is tomorrow's inventors and innovation sectors some 10, 20, or 30 years from now that will be the ones judging the passage of the unitary patent. It is also the decisions we take now that will define whether we can make the most of the possibilities that exist. Emerging technologies, frontier technologies, as the UN called them in its latest Technology and Innovation Report, already represent a market of some $250 billion. But by 2025, that's expected to grow tenfold to $3.2 trillion. And at that point, it won't just be the inventors of tomorrow. It will be all of Europe's citizens who will ask whether we really did everything we could to keep creating an IP system capable of delivering those benefits, and ultimately, to support inventors in their quest to create that safer, smarter, and more sustainable world to which we all aspire, and which we need now, more than ever. Thank you for your attention.
Thank you very much, Mr. Campinos. We'll open now the floor to the coordinators. We will start with Ms. Walsman. Ms. Walsman, you have 3 minutes.
Ja, sehr geehrter Herr Vorsitzender.
Yes, Chair. Mr. Campinos, thank you very much for your presentation. And I really would like to thank you very much indeed for the EPO's staying operational despite Corona. Really very many congratulations to you and all your colleagues. I think that this unified patent system and the ratification of the agreement on the single patent is extremely essential because it does solve a great number of problems and will avoid a great deal of extra bureaucracy. So I'm happy that our constitutional court in Germany has helped to lead the way towards this. Now, the questions I have. The number of European patents has gone up. And qualitatively, they are the highest of they're very high level worldwide. But if you look at Asia, intellectual property is developing considerably with huge bounds, leaps and bounds. What are the obstacles you think need to be overcome? What measures are absolutely essential to ensure that the EU can continue to keep pace in terms of technical leadership, particularly with regard to intellectual property and the national issues, the national conflicts that we're having? Are there serious obstacles? Now, national issues and conflicts and disputes, what do you think about the systems that are happening, the patent trolls? What do you think about the dimensions of that problem as it exists? What are practical solutions to the problem to try and ensure that the patent law cannot be abused? And then in terms of legal disputes, what challenges do you see in terms of the licensing of standard essential patents that are important for 5G and other internet matters? How can the problems raised be solved? Should we, in your opinion, be looking to initiatives from the world of industry, or should the legislator actually intervene in terms of regulation? And also, what do you think the main reason is that there are so few patents? I'd really like to know what your view is. And I have a whole range of questions, but in my role as rapporteur for the action plan for intellectual property, I am absolutely certain that in the future we'll have many opportunities to discuss these various issues in the context of a very fruitful cooperation. I really do look forward to getting to know you. I'm pleased to have met you today. Thank you in advance for answering my questions. Thank you.
Thank you very much, Ms. Walsman. We'll do a first round, and then maybe Mr. Campinos could reply more than one question. So we'll move on to the next speaker, Mr. Wolken. You have 3 minutes.
Yes, thank you very much, Chair, and thank you very much for being here today for answering our questions. I have 2 small but I think relevant questions concerning artificial intelligence. There is a wide academic consensus that the legal concept of inventorship requires a human being to be the inventor, and you shortly touched this issue in your presentation too. In this context, the EPO has now refused, in 2 instances, patent applications indicating an AI system as the inventor. It seems, however, that the applicant in these cases has filed an appeal against these decisions, and that similar developments are taking place at international level. So, therefore, my question is, will the appeal decision confirm the conclusion of the first ones? And if so, are you aware of any factors, legal or technical, that may one day challenge this legal concept of inherently human inventorship? And one additional question, as you mentioned the pandemic during your introductory speech, would you have an overview on the numbers of patents filed in connection with COVID in regards to medicines and medical devices? Moreover, have you noticed any additional filing of secondary patents in connection to the pandemic, prolonging already existing patents for specific medical products? And I know that this isn't the place to discuss the TRIPS patent protection, but I just want to use the opportunity to express my regrets that the European Union refuses the patents waiver so desperately needed for many parts of the world. And I hope that Europe can play a better role here to make available patents for people who are in desperate need of vaccines. But as I said, this is not the place to discuss, but just a side note. I'm looking forward to your answers, and thank you very much for the exchange today.
Thank you very much, Mr. Volkan. I'll give now the floor to Ms. Melchior. You have 3 minutes.
Thank you very much, Chair. And I would also address the COVID-19 situation. It is possible to make exceptions on behalf of societal issues, and therefore it's important that we make use of this when looking at access to medicine. I will now speak in Danish, as there is the opportunity for speaking in Danish. Jeg vil tage lidt tilbage.
I will go back in time to 2014, when I was part of the Danish referendum campaign, and we talked about patents. Many were concerned that there would be more patents on software in Denmark. You can't have a patent on software alone. I said that it was important that Denmark is part of European cooperation, even if there is an EPO practice which we're not happy with. And if it turns out, what should we do? I looked over at patents on software, and I've found a publication on the 13th of December last year. There's a software patents for cars. Now there's hardware and control devices, but it's about controlling the software of the cars. This is a good example that applicants can find a way around this. Is there a possibility that that the EPO can change the application system, or should we look at the guidelines and the judgments, and how can these guidelines be changed? Be changed to improve software copyrights. Thank you very much.
Thank you, Ms. Melchior. Mr. Le Breton, you have the floor. You have 3 minutes.
Merci, Monsieur le Président.
Thank you. I would like to thank Mr. Campinos for presenting the work of the EPO. Personally speaking, I'm absolutely convinced that it is extremely useful, the office, and I'd like to thank him for all the efforts that have been made to protect human creativity throughout Europe. So the office has been extremely successful and is very attractive because 38 member states it has 38 member countries. And in terms of competitivity being promoted. 50% of jobs are closely linked to patent issues. And also with regard to public information, because the database of the office is very much used. 600,000 users a month. That seems to me huge. That's excellent. So I also greatly appreciated the clarifications you gave that an inventor has to be a human being and cannot be a system of artificial intelligence. And I think that's a very good thing. I do have a few questions I want to ask, despite all the compliments I've given you. My first question is, a few months ago, Europe had a huge problem. Should we accept patents, the need for patents for vegetables and animals? And on the 14th of May 2020, the Chamber of Appeal of the office concluded what I wanted, which was that we shouldn't have that kind of patenting system. But there were a lot of reactions and they weren't all positive. I'd like to know where we stand on this. Are we still very much holding to that position, or have recent debates changed things? That interests me greatly. Also, China. China is extremely dynamic at the moment in terms of patents. They are competing fiercely with us. And I'd like to know what you're proposing at your level in terms of trying to counter the ferocious competition mounted by China. And the hypothesis of one single patent that would replace the current fragmented system. I fear that the member states are not prepared to accept that for the moment. But so aside from this solution, do you have any other areas of research you're exploring that would enable you to meet the Chinese challenges? Thank you.
Very much. Mr. Campinos, maybe you can now reply to all these questions.
Try, dear Chair. I will try. It is in fact true that we saw a huge growth of Chinese patent literature in the past years, and probably when we look ahead, most probably China will become dominant in prior art patent literature. And this is not only true on patents, this is true on trademarks, it's true on design. I don't know, Chair, if you know, but we receive around 185,000 applications per year at EPO. China is well above 1 million. And the share of European patents filed by Chinese applicants, or Chinese residents, may I say, because there's a lot of European companies actually working from China, is rising and rising and rising. So I think that, the Industrial Revolution came, we made the first patent laws, the Americans copied us, then the Japanese copied the Americans, then the Five Dragons copied the Japanese and the Americans and Europeans. The Chinese did so, and now they're innovative, and that's a fact of life, and we need to deal with that. So I think that answering 2 or 3 questions I'll be asked by 2 or 3 members of the parliament, the only thing we can do as an executive branch, not a legislative, an executive branch, is to really ring-fence the invention to what is novel and possesses an inventive step. And that's why maybe we have 185,000 applications compared to the 1.5 million applications that the Chinese have, or the 600,000 that the Americans have. At EPO, we really mean quality. And quality means ring-fencing the invention to what is novel, what contributes is compared to what came before. And that will help by publishing it to contribute to what's going to come after. On the SAPs, I think that DPO made clear that we cannot be judge and party. So we cannot assess whether a patent is an essential patent or not, as such. But we stand ready to support the EU institutions with our experts to deal with that. So whether you call it arbitration or whether you call it mediation, we will be ready to support with our experts in whatever formation that the EU thinks is right to deal with the SAPs/friend. And I think this is an important issue that we should tackle. AI. Well, actually, I do think that AI, primarily for now, as we speak, is not an issue that relates that much to law, because we made it clear at the first instance, and now, as you rightly said, is in our second instance, in our quasi-jurisdiction body, the Boards of Appeal of the EPO, inventions can only be filed by humans. That's clear. For now. In 10 years from now, I don't know what will be the answer to that question. But in the meantime, one thing that we are facing is that you know that the inventions are compared to whatever has been invented before, whether protected by a patent or explained in a scientific paper. It doesn't matter whether it is from China or Portugal, France or Spain. It doesn't matter. It's worldwide. It's a prior art concept. Now imagine that algorithms start producing prior art and prior art and prior art. Nothing prevents, the algorithms to produce prior art. So I think that in the medium and short-term range, this is the issue that we will need to deal with, is that the capacity of algorithms to produce prior art, to which we have to compare the inventions filed by humans to determine if they're novel and have an inventive step. So that's where I want us a little bit to focus in, and that means better search engine, better databases, and that's where we are focusing now. The waiver. I understand this is a political matter, and on political matters, the EPO has no stand. The EPO's member states have a stand, not EPO as such. But may I tell you something, madam, that was taught by one of my favorite teachers, a constitutional teacher. He said to me, Antonio, if you want things to remain as such, you just have to change the law. And if we think that by changing the law, we're going to solve an industrial issue, I think we are mistaken. It might be nice for the headlines of the newspapers, but changing the law will not solve the production capacity. The distribution capacity will be there tomorrow, because now we are solving a production capacity through voluntary licensing or compulsory licensing, which is already foreseen since 1883, Paris Convention, TRIPS Agreement, Doha Declaration, regulations of the EU. So the tools, we have them. But the problem is not a problem of the law. The problem is a problem of production, and tomorrow you will see a problem of distribution. So, IP, as I said, is a tool that serves to secure and protect the investment in innovation. There are many others. Trade secrets. Who likes trade secrets? I don't like trade secrets. Licensing, open innovation. There's so many ways to secure and protect the results of the investment innovation. IP is one, and that's it. And I think it's fulfilling its role. In 1 year, we develop molecules, licensing agreements. We're talking about compulsory agreements, which are there on national legislation. So the tools are there. We don't need to change the law. We need is to sort a production capacity and tomorrow, not in Europe, but elsewhere, a distribution capacity. And I think that there the Commissioner Breton is doing a superb job. AI. Now, AI, differently from the US and other jurisdictions, is not protected as such. In the US, AI is protected as an algorithm, as a patent, not in Europe. In Europe, what we protect is the technical effect of this AI algorithm. So it means that it's, to put things in a simpler way, it's the interoperability between the software and the hardware. And that's what we protect. We do not protect the algorithm as such. This is not protectable. This is copyright. In the US, it would be protected as such. We protect the interoperability between the software and hardware was a technical effect, a technical result. That's why we protect autonomous vehicles, for instance. You got an algorithm in the car that makes the car respond or not to certain situations, and that is what we protect. We do not protect AI as such, differently from the US, which might question, a competitive advantage compared to the US, or not. But still, in Europe, we do not protect software patents. This is a myth. We protect the interoperability between the software and the hardware. And rightly, we do so. And now, coming to the pharma world and to the biotech world, I think that the Boards of Appeal, like you rightly said, sir, has issued a very important decision, who confirms the reading that we had following the biotech regulation issued by the EU institutions. And that's where we are. We do not protect patents on animals and on plants as such. Again, it's a little bit the same reading than with AI. The same reading than AI. Chair, I hope that I answered to, did I forget anything, Chair?
I think so. It will be really interesting also to listen to the Commission on those answers that you gave. But first we have another speaker. We have Mr. Breyer. Mr. Breyer, you have 2 minutes.
Mr. Breyer, please press the speak button. Thank you.
Thank you very much, Chair, for the opportunity to ask questions. A lot of questions have been asked by my colleagues already. And regarding the question on software patents, maybe I might follow up by asking, do not the guidelines and practice of the office open up back doors to indirectly have software patented as part of other systems. Secondly, on the Unified Patent Court, some say that this agreement could enter into force even though London is still nominated in the annex as a seat of the court, which this opinion is not shared among all legal experts. And I wonder, would it help if we sought an opinion from our legal service on this issue? How do you think can we deal with this question and seek legal clarity on this issue? Thirdly, when it comes to the decisions that the EPO takes and the administrative acts, which court will actually be competent to review your decisions? Do you think that there is that all kinds of decisions are covered by legal review and legal redress competences, and which courts would be competent for that? And finally, when it comes to the fees of the proposed court, it seems that the scales goes up to 20,000 euros, which seems to be a lot more than is being charged in many member states so far for simple cases, such as would be of interest to small and medium-sized enterprises. So how do you think can the concern be addressed that court fees will make access for SMEs to this legal review more difficult and more costly?
Thank you very much. We don't have any more members asking for the floor, so maybe Mr. Campinos, you could reply Mr. Breyer's questions and also give us your concluding remarks. You have the floor.
Yes, thank you. Thank you very much, Mr. Chair. As regard the patent software, I think I rest my case. There's no patent software in Europe. Despite whatever you can read in the blogs and even in newspapers, there's no patent software in Europe. There's patent software in the US and in other jurisdictions. In Europe, software is protected through copyright, which I argue might not even be better, but I won't dwell into that. You know the extent of of copyright protection, right? What is patentable under the EPC and under the jurisprudence of the Boards of Appeal is the interoperability between software and hardware. I rest my case. The UPP. It's true that there's a discrepancy between two regulations. The funding regulation of the UPP and the PPA, the Protocol of Provisional Application, which clearly designates London as being the seat of one of the branches of the Central Division. But we need always to refer to the upper law. And the upper law do not talk about London. So I think this is a matter of interpretation, and whether London is referred in a secondary instrument or not, it's not the main point. The main point is the decision of Karlsruhe, of the Constitutional Court, that we are all awaiting for Karlsruhe to give the green light for us to complete the internal market as regard IP. And in the process of industrial recovery, I think that the unitary patent is a tremendous important tool. So let's await. We all trust about the fairness of the constitutional courts across Europe, and in particular in Germany, and we will wait for the decision. You ask which court I think, sir, is called to answer to any decision that is made in the frame of the EPO's activities. Well, actually, it's a court which has been set up in the frame of the Labour International Organization. And the name of this court is ILOAT. So ILOAT is responsible to review any decision I may take or the office may take as regard, for instance, staff issues or whatever relates to the contracts of my staff. It is true that it's not a perfect system. It is true that we are not functioning in the EU remit. So we do not fall under the ECG or the General Court, but we are overseen by the International Labour Tribunal, which belongs to the International Trade Organization in the remit of the United Nations. The fees, 20,000 euros. I don't know where you got that figure, sir. Actually, the unitary patent is a patent that comes from an application that will go forward an European patent application. And the application fee, for a start, is a little bit more than 1,000 euros. And then you pay the search fee. And then you pay the examination fee. And then you pay the designation fee. And what you were referring is the designation fee, I think. Now, the designation fee foreseen for the unitary patent is worth the 4 biggest fees in the 4 biggest jurisdictions. So with the amount of 4 fees, UK, well, formerly UK, France, Germany, and you name it, whether it will be Poland after UK, you multiply this 4 and you've got the fee for the unitary patent, for the designation fee, sir. Not for the applying fee, not for the examination fee or the search fee, for the designation fee. So when you compare 27 jurisdictions, or 25 as it stands, because Spain has not joined the system yet, and Hungary, apparently for constitutional reasons, cannot join the system yet. So imagining that is 25 jurisdictions where the unitary patent will come into force, compared to 4/5, you will have 25 jurisdictions where you have one single right with one court protecting your invention. So I think this is a huge way forward. Chair, I think I answered all the questions, but I'm in your hand.
Yeah, I think so. We don't have any more questions, so thank you very much, Mr. Campinos. It was a very interesting exchange of views. on the implementation of the unitary patent. I believe that we will have to continue on this exchange of views in the near future, hopefully maybe in Munich next time if the situation allows it. And we also look forward and we hope for the completion of the German ratification procedure as soon as possible as well. So thank you very much, Mr. Campinos, for being here today. We'll move now to the next item of the agenda, item 6. A status for European cross-border associations and non-profit organizations. Today we have the exchange of views, and I will start by giving the floor to the rapporteur, Mr. Lagodinsky. You have 5 minutes. He's not connected. Yeah, because we are quite ahead of time. So let's adjourn for a few minutes, and in the meantime we'll call Sergei to try to make him connect. Hello again. So we continue. Item 6, the Statute for European Cross-Border Associations and Non-Profit Organization. Today we have the exchange of views. I'll give the floor to the rapporteur, Mr. Lagodinsky. You have 5 minutes.
Thank you very much. It's great to address this issue. Finally, it's been a long road, but the main principle that we're talking about here is that no democracy is possible without civil society, and no European democracy is possible without freedom of associations. And that's probably the starting point of what we discuss here. We will be discussing with the colleagues, some of whom I've already had the pleasure to speak on the issue, of how to make yet another attempt to create regulatory framework for our civil society. Because what we have seen during the past years is clear for all of us. Without safeguards, but also without enabling